Today we are going to discuss about who is a minor and what are the precautions to be taken by a banker in opening an account for minor. So first we'll see the meaning. Minor is a person who has not completed his 18 years of age is considered to be a minor. In case of where guardian to the person or property of minor is appointed by the court, the minority extends to the age of 21 years. That means a minor is a person who is under the 18 years of age will be called as a minor. And also, if there is any legal guardian is appointed by the court of law, in that situation, he or she will remain a minor till the age of 21 years. That is the meaning for minor. Next paragraph. Under Section 11 of Indian Contract Act 1872, a minor is not capable of entering into a valid contract. And a contract entered into by minor is void. That means when a person opening an account in a bank, that arises a contractual relationship between a banker and customer, isn't it, right? So, but when a minor is opening an account in a bank, in that situation, the minor is not a capable person to enter into a contract. Even though if he is entering into any contract means that contract will be void. That is the meaning for second paragraph. Moving on to the next slide. Minor and banker. In case of minor, a banker would open a joint account with a natural guardian. So when a minor wants to open an account in a bank, the banker always prefer to open an account with a natural guardian. Even they won't have an individual account, they always used to have a joint account with their guardian. The guardian may be their father or mother, they can be a natural guardian, or else sometimes a legal guardian will be appointed by the court according to the will of father or his mother. And why the minor wants to open an account means to encourage the habit of saving. The bank open minor account in the name of minor, and also they are allowing the minor people to operate their account. So when the minor is opening an account, they have to fulfill certain conditions. The conditions are the minor should be below 18 years and he should be illiterate people, and the banker should be very careful about no overdraft facilities will be allowed to minor account, and also two minors cannot open a joint account. At least one person should be adult. As I told, the father will be a natural guardian for opening a minor account, but now RBI has authorized mother also to sign as a guardian. So these are the certain conditions to be fulfilled by the minor and the banker. And very important thing is, as we know that it is true minor is not eligible person to enter into a contract, right? But the minor can issue checks, and those checks can also be paid by the banker and it will be debited to the minor's account. That means what? They can operate their account, but there is a certain limitations. Now instead of current account, they have to open a saving account only. So there are certain conditions or precautions have to be taken by a banker when they are opening in minor account. And do you know why minors are not allowed to have a current account? Because for current account holders, the banker should provide overdraft facilities. Suppose if any overdraft facilities is provided to the minor people, and if they are not repaying within a duration means the banker cannot file a case against the minor, because the contract will be void when a minor is entered into a valid contract. So that is why we are telling the minor, if they are entering into any contract means even it will be void. The banker cannot file a case against the minor people. Moving on to the next slide. Precautions while opening a minor account. So that means precautions to be taken by a banker in opening an account for minor. The first point, Though current account can be opened in the name of minor, as I told you, even the minors can be allowed to open a current account, but it is advisable for a banker to open only a saving bank account, not a current account in the name of minor, because the bankers are not ready to take any kind of risk. That is the first point. It is not advisable for a banker to open a current account in the name of minor, because what is the reason? If in future if any problem arises, means the minor will not be personally liable for such in any overdraft. The second point, caution. It is advisable for a banker to open a minor account in the name of his natural or legal guardian. So for the benefit of the minor, doesn't consider whether it is a saving account or current account, but for a banker, they have to open a minor account only in the name of his natural or legal guardian. Natural guardian means father or mother will be a natural guardian. Legal guardian means when it will happen in case of there is no legal natural guardian available, means in that situation the court may appoint somebody who is connected to the minor. So such a guardian will be called as a legal guardian. So that is a second advisable for a banker when they are opening a minor account. The third precaution is when a minor account is opened in the name of his guardian. In that situation, what are the certain precautions taken by a banker? That means what are the points or what are the formalities should be observed by the banker. We'll see one by one. The first one is the account should be opened in the following style only. Magesh, natural guardian of minor Anand. So this is the style should be followed by the banker, because here minor is a Anand and guardian will be a Magesh. So in this format only the banker have to note down. The second point, the banker should obtain the specimen signature of the guardian, as they require to be referred to at the time of the payment of the checks issued by the guardian. So therefore, the specimen signature of the guardian is required when they are opening an account. The third point, it is enough if the bank gets a specimen signature of the guardian. So that means what? He need not ask for the specimen signature of minor, as the account in question will be operated only by the guardian and not by the minor. That is a third point. Fourth point, it is better that the banker note down the date of birth of the minor in the account opening form, in his ledger, and also should be in the passbook. Why? What is the need of it? Means this information helps the banker to know to when the minor attains the maturity. So when the minor person have attained the age of 21 years, in that situation the duty of the banker is they have to open a new account, and all the credit balances of old account will be transferred to new account. So that is why they are note downing the date of birth of minor. Fifth point, as soon as the minor attains the age of majority, the banker should close the minor account. As I told you, the same procedure should be followed by the banker. So they have to close the minor account and open in the name of his guardian. That means and open a new account in the name of ex-minor himself. That is a very important precautions of a banker. The last point, when a new account is opened in the name of erstwhile minor, the banker should obtain the specimen signature of erstwhile minor. That is also should be duly verified by the guardian, as the new account will be operated by the erstwhile minor. So that means after opening a new account, now what is the duty of the banker? They have to obtain the specimen signature of a minor. So in this situation, the banker should obtain the specimen signature of a erstwhile minor, and that also should be duly verified by the guardian. So these are the certain observations should be noted down by the banker. Fourth point, in case an advances is granted to the minor intentionally, it is advisable for a banker to ensure that the advances is granted for the purchase of necessities of life. only the minor's property can be made liable and minor cannot be made personally liable. Which means, you just imagine banker have given a advance facilities to the minor for his necessities of life. Okay, so how he can given that low advance facilities means against the security of minor's property. Okay, in future minor is not repaying their advance amount. In such a situation, minor cannot be a liable person because minor cannot enter into a valid contract, even though if he is entered into a contract means it will be void one. Okay, so that is why we are telling the banker can make a liable only for the minor's property. He cannot make personally liable of a minor. Suppose in case in any advances have given to the minor against the personal security of a third party. Okay, you just imagine three parties are there. One is a banker, one is a minor, and the third person. Okay, so for a minor to avail the loan facilities, the third party have given their personal security to the banker. In this situation, okay, in this situation the third party will be like a principal debtor. He is not just like a guarantor, he will be a principal debtor. In future, if there is any non-payment of advances by the minor means, now the banker is having one advantage. He can file a case against the personal property of a third party. That is the only advantage the banker is having when they are dealing with a minor. The fifth point is minor as an agent. When a minor is appointed as an agent to operate the account of another person, the banker should take certain precautions. So that means what? The minor can act as an agent. So what are the precautions to be taken by the banker is, the first important thing is the banker should obtain a written authorization from the principal regarding the appointment of a minor as his agent. And also the principal have to given a detailed note of what are the powers have given to the minor agent. Okay, and also the banker should see that the minor agent does not do anything beyond the powers which was given to him. That is the call. The minor can be act as an agent on behalf of his principal. The sixth point is minor as a partner. Partnership, we know that it is based on a contract between two or more persons who are eligible to enter into a contract. But a minor is a not eligible person to enter into a contract, right? So he cannot become as a full-fledged partner of a firm. But he can be admitted only to the benefits of the partnership firm with the consult of all the partners. Even if one partner is not satisfied, if he is not interested, means the minor cannot be act as a partner. So with the consult of all the partners, the minor can be appointed as a partner. So why mean in future if any problem arises or if any debts are incurred in this organization means the minor will not be liable person. So that means what? He will be liable only for his company shares and the profit. Okay, so that's why with the consult of all the partners only the minor will be appointed as a partner. Seventh point, minor as a joint account holders. So an account can be opened in the joint names of minor and an adult. Such an account can be operated in as usual manner. So however, the minor cannot be made liable for any overdraft or loan which was given on that joint account. So we have to keep it in a mind. That means the banker have to keep it in a mind, like while lending on such an account, it should held in the joint names of minor and an adult or adults. That is a very important thing. Moving on to the eighth point, minor as a guarantor. Minor cannot be made liable as a guarantor on a contract of a guarantee, because if he is entered into a contract means that contract will be void. That means what? It is not a valid contract. So a banker should not accept the guarantee of a minor for a debt due from any principal debtor. He can just act as an agent, but he cannot give any guarantee towards the other people. So that means the minor cannot be act as a guarantor. Moving on to 9th point, minor as a trustee. Minor cannot be appointed as a trustee like a guarantor. So a banker should not permit a minor to operate a trust account. Okay, so as a banker they have to take a precaution. If a minor wants to act as a trustee means he should not allow the person. That means the banker should not permit a minor to operate the trust account. The last point, 10th point, minor as a executor. A minor may be appointed as an executor, but he cannot act as such until he attains the majority. So that means what? Until he attains the age of 21 years or 18 years, he cannot act as an executor. So until that he can be appointed as an executor, but he has to wait until his majority. So it is advisable for a banker not to permit a minor to operate a bank account as an executor. He can permit banker can permit the minor. When he will permit the minor? When he attains the age of 18 or 21 years. So these are the precautions to be taken by a banker when they are opening an account for a minor account. I hope you people got a clear picture about the precautions to be taken by a banker in opening an account for minor. Thank you.